But you didn't file a motion for leave to file an untimely joinder. Wouldn't that be your responsibility, counsel?
That's correct, Your Honor.
And so I'm going to, first matter on for today is pages 1, which is Myles Hunwardsen versus Affinity Lifestyle et al. And remember, the easiest way to do the appearances on this is I just walk through what it shows on the clerk's printout. So, counsel for plaintiffs, please, on Hunwardsen. Would you like to make your appearance?
Good morning, Your Honor. Eric Pepperman for plaintiffs.
Thank you. Anyone for KeHE Distributors? Nobody? Ms. Frister, are you not?
Yes.
I thought I saw you.
Yes, Laureen Frister for KeHE Distributors of Nevada.
Okay.
Caitlin Zapf for KeHE Distributors of Nevada as well.
And I'm sure, remember, the stipulation did require parties be on audio visually, please. Thank you.
Yeah. Yes, Your Honor. This is Laureen Frister. I'm getting a spinning thing on my computer, so I'm connecting.
Okay.
One moment.
Of course, we'll continue with the appearances. Scientific Instruments, please. Anyone for Scientific Instruments or SID US Inc.?
This is Ryan Flanagan for Hanna Instruments and SID Inc.
So you Scientific Instruments Development International Inc. and SID US Inc.?
Yes, Your Honor.
Okay. And then you're also Hanna, which is on my next page. Okay, thank you. NSF International.
Good morning, Your Honor. Jonathan W. Fountain.
Okay, thank you. Albertsons LLC. No one? Okay. United Natural Foods West, I believe, is here in court. Counsel, here for a couple of them. You want to give me your few? Go ahead.
David Spurlock, Your Honor, bar number 2565.
And you're here for United Natural Foods, WFM Southern Nevada, and are you also here
That should be it,
for
Your
Whole
Honor.
Foods Market?
Yes, Your Honor.
Okay.
Thank you.
Thank you. Appreciate it. Okay. Hanna Instruments, we already got taken care of. Milwaukee Instruments, please. Did anyone check in? Usually it's Miss Lowell. No one's here for, okay. Costco.
Good morning, Marissa Fehrman on behalf of defendant Costco Wholesale Corporation.
Okay, thank you. ETT1 LLC. No one. Real Water Inc. and Affinity Lifestyles.
Good morning, Your Honor. Daniel Joslyn here on behalf of Real Water and Affinity Lifestyles.
Okay. Did you put your bar number in? Because we don't show you.
He did.
You did.
I
Okay.
just wrote it in, but it's a 14725.
Thank you so much. Okay. Cross Nevada Beverage.
Good morning, Your Honor. Colt Dodrill, bar 9000 for Nevada Beverage.
Okay. Real Water of Tennessee.
Morning, Your Honor. Jim Cavanaugh, Gordon Reese, Las Vegas, third-party defendant, Real Water of Tennessee.
Appreciate it. Thank you. Okay. Looking to see Real Water Gold Coast LLC. Is that also you, Mr. Cavanaugh?
No, ma'am. That is same counsel as Affinity and Real Water, Inc.
Okay, so
he just forgot to tell you, but
That's correct. I apologize, sir. Yes, I'm here representing them as well.
and remember, I can see your face, but you need to state your name. The I.
Yes.
Thank you.
Apologies. Yeah, Daniel Joslyn here on behalf of Gold Coast as well.
Real Water Gold Coast LLC. Okay.
Yes.
Thank you. Anybody who has not yet had a chance to make an appearance wishes to make an appearance? Okay. So, then we're going to move forward. What we have today is Defendant Nevada Beverage Co.'s motion to bifurcate trial, document 317. Defendant NSF International's non-substantive joinder, which we need to address because of the timing issue. Document 360, and when I say timing issue, EDCR 2.20D on the timing on a joinder. I can have that question, or somebody might be raising the question. Plaintiff's opposition, document 358, and Nevada Beverage's reply, document 366. So what my intention was first to really address the joinder issue to see if there was an issue from plaintiff's position, because realistically the joinder came in after the opposition and it's a joinder to the underlying motion, but that's why it's a document 360 and yours is a document 358 and it was filed after you had already filed your opposition. So I need to see if that is an issue or if it's waived. Counsel for plaintiff, what's your position?
Your Honor, I did see that the joinder was untimely. It was a non-substantive joinder. We had a pending motion to dismiss, and the order wasn't entered. It was around the same time, and I just wasn't sure if that was the reason for the untimeliness. If it did not conflict with the timing of the motion to dismiss, then we would object as the joinder is untimely.
So counsel, can I kind of break that down? You are or are not objecting. You said if it was this, then we would, so I'm not sure.
Your Honor, we object to the joinder is untimely.
No worries, I just need to know your position. I appreciate it.
I'm sorry for being less than clear.
No worries, I just wanted to make sure, because now I'm going to ask NSF International if they have some basis on how they think that their joinder is timely, and I don't want any of the substantive arguments, I'm just realistically dealing with the procedural issue to see if that needs to be addressed today as well. So, Counsel for NSF, do you wish to be heard just on that procedural aspect?
Just briefly, Your Honor, this is Mr. Fountain speaking. I recognize that the joinder was filed, late, later than the rule requires. We think that's we filed it as soon as we realized that the motion was something we wanted to join in. We did have, issues with the motion to dismiss not being resolved. And, frankly, I think the technical objection to the late filing of the joinder doesn't seem to be a great reason for not allowing it.
Well, counsel, how would they have been able to oppose it since you filed it after their opposition and didn't seek leave of court to file it untimely or stipulation with the parties?
Well, I'm certain if they wanted to oppose it, they could have found a way to do that. They certainly could have filed something with Your Honor.
What said opposite? How would they do that? They're not allowed to file supplemental pleadings without leave of court, and it would have been untimely, right? And
well, they could have filed a motion for leave to file an opposition.
But you didn't file a motion for leave to file an untimely joinder. Wouldn't that be your responsibility, counsel?
That's correct, Your Honor. I guess we didn't realize that we needed to seek leave to file that joinder, and I'll take responsibility for that.
And you understand you still haven't even done your filing fee? That's been mentioned a couple times. While this court is not administration, they have asked us that if we see something, because it pops up on our screen anytime I open the case, still shows from 4/24/2023, NSF hasn't even filed their filing fee.
I was unaware of that, Your Honor. We'll pay it today.
That doesn't impact the joinder issue. It's just since that happened to pop up, as you were speaking, I thought I just would mention that because they asked us at least to mention that. So I follow what administration asks us to do. Okay. Here's what. Court's going to evaluate that after I hear the oral argument, whether I should or should not take into account the joinder. And realistically, the reason why the court's saying that, I'm going to give you the parties wish an inclination on the motion to bifurcate, or do you just wish to have oral argument and then make the court have a ruling? The court's fine either way. If you wish an inclination, I can give you an inclination. If you don't, that's fine as well. Counsel for movement, it's your choice because it's your motion.
Thank you, Your Honor. Yeah, we would be interested in understanding the court's inclination as it may help assist with argument.
Although the court's inclination is to deny the motion to bifurcate, realistically for a couple of reasons. One of the reasons is, remember, you're a cross-claimant, and you're a cross-claimant against affinity, but yet nowhere in the motion did I see that issue addressed and how the court could, for judicial economy or any basis, realistically, if you're asking for Nevada Beverage to be addressed separately, then that really would require 2 trials with all the substantive issues on affinity as well, because unless you're asking only the motion to bifurcate Nevada Beverage in its defendant role but not its cross-claimant role, but then that didn't seem like that would, from a practicality standpoint, a judicial economy standpoint, and also could risk confusion to the jury if you then came in on a cross-claimant role on a larger trial when everything against affinity. And since I didn't even see that that was addressed in the motion, but yet you are a cross-claimant, that would raise the concern on how I could really bifurcate Nevada Beverage, which is the relief requested, not. So I see the inconsistency there. With regards to Nevada Beverage and its defendant role, I'm not seeing, independent of the cross-claimant issue, is I really didn't see how that would meet the needs of what is asserted in your motion, which you say is to get, fair trial and to be treated. A lot of those would have this court to make determinations as to what actually is the status of a couple of plaintiffs on issues that have not yet been specifically brought before this court. I'd have to make certain assumptions as far as the 2018, 2019 versus what you call kind of the major outbreak or the outbreak cluster. Has been phrased in a lot of different ways. And the court can't make that determination when it hasn't yet really been presented to the court. So I can't make that assumption that that exists, which then would not lead to the meeting the criteria for a bifurcation. So those were the court's just inclination / I was going to ask a question on the cross-claim issue, but there it is. And counsel, feel free, that's just an inclination, feel free to set forth your argument.
Thank you, Your Honor. I'd like to specifically address the court's concerns regarding the cross-claims. Those were addressed on page 16 of our motion, where we cited some authorities that those are rights in equity. Those are claims for contribution and indemnification that would not go to a jury, and that those could be resolved in a bifurcated fashion. I also just want to clarify the relief that Nevada Beverage is seeking, which is not to bifurcate out so Nevada Beverage is tried separately. We're trying to bifurcate because
Counsel, you're cutting. I'm stopping you for a quick second because you may not realize you're cutting in and out. Every time you start to lean back, I think you're cutting out. So you might want some. If you want to be heard clearly, you might want to be a little closer to your computer. Let's try that again. I understand it's not Nevada Beverage specifically. You're asking for 2 of the plaintiffs, your 2018 and 2019, which is part of the challenge the court was trying to say is it having to make that assumption that they are different when that has not yet been presented to the court directly. Go ahead, please.
Okay, Your Honor, thank you. In terms of how they are different, those allegations come directly from the complaint and the discovery that's happened since we were last here in October, where we moved to sever, and the court may recall it was inclined to grant that and decided that perhaps after some discovery, if it was warranted, perhaps bifurcation may be the more appropriate remedy under 20 rather than the Rule 21 severance that we had requested. Now that discovery has occurred, we can tell that plaintiffs have been strategically joined in a diverse cross-section, and there is a natural demarcation between the outbreak plaintiffs that are not suing my client and the non-outbreak plaintiffs that are or were, and that's Brody and Hunwardsen in the 2018 and 2019 that the court referenced earlier. And I'll give you some examples Discovery has one that
Counsel, you're cutting in and out again. When you started with let me give you some examples, then you cut out. So you might have missed some words in there. I'm not sure if your connection, or you might want to check if you have another device close to your computer or something, but you are cutting in and out, just in case.
Thank you, Your Honor. I'll try to be more clear. Everything related to the outbreak plaintiffs has no bearing on the or the non-outbreak plaintiffs. That includes plaintiffs' references to hydrazine. The E2 concentrate was found only in concentrate made in 2020 that obviously could not have been consumed by the non-outbreak plaintiffs. Same thing with the retail bottles that plaintiffs rely on, where Eurofins tests found minute traces of hydrazine. Those bottles were made in 2020 and 2021 and could not have been consumed by plaintiffs Brody and Hunwardsen. Plaintiffs' reference to new and perhaps undertrained employee Casey Aiken did not make real water in 2019 and 2018. The bad pump, the ozonator, all the expert issues, the bad batch, all of that in the FDA investigation all relates to 2020 facts that would be excluded relative to Myles Hunwardsen and Ms. Brody's claims. What I cannot do is move in limine to exclude under 48035 three plaintiffs whose claims are unrelated to those that are suing my client and highly prejudicial. And we're focusing here on the prejudice, which is both in the parchment factors adopted by ACAB and in NRCP 2121B. And all the evidence that plaintiffs want to have, everything they argued in their opposition specific to the circumstances or the series of unfortunate events in 2020 is irrelevant and would be excluded at a trial related of any claims against my client. So those are the facts that discovery confirmed. We're really looking at two separate universes of plaintiffs and two separate universes of facts. This is not a uniform product case such as Guinness v. Mapes that speaks to something that has not changed. Guinness v. Mapes, we got the same hotel, the same type of doors made in the same factory by the same people, installed at the same time, and the issue was the same. Real water is the epitome of change. Discovery told us there's different factories, there's different equipment, they're made in different states by different personnel, resulting in different products that are bottled on different machines at different times. And most of that is not relevant at all as to the 2018 and 2019 claims. You simply can't try these apples and oranges together and expect Nevada Beverage to have a fair trial. And while we moved under Rules 20B and 42B, we also moved under Rule 1, which is for a just determination. And there's simply no way for Nevada Beverage to get a fair trial in a consolidated action of these unrelated plaintiffs. And it's fairly simple when we look at it, that's a natural line of demarcation. The 2018 and 2019 folks are different transactions. We go through that, and I think we spoke a lot about that when we were last here in October. It's different transactions, it's different evidence, it's different folks, it's different depositions, timeline. It's a complete disconnect that needs to be addressed. And those two plaintiffs' claims against the defendants that they are claiming against absolutely should be tried separately from the outbreak plaintiffs, Sosa, Schaefer, and Hartshorn, that are not presenting any claims against my client and other defendants here.
Are you saying you're speaking on behalf of other defendants or just your client, counsel?
I am not speaking on behalf of any defendant other than Nevada Beverage. I will point out that no defendant has opposed my motion, and as the court indicated earlier, one defendant had joined my motion. Plaintiffs raise a number of issues that I don't think the court should consider, including what did or did not happen in the Gallagher case, or the fact that no other defendant perhaps accepted.
Okay, counsel, you're cutting in and out. It is really difficult to hear you. If you've got to check your equipment, please. If you wish remote appearances, you've got to make sure you have the right equipment to do it. So it's just, I heard you say Gallagher, but if you said something after Gallagher, it was cutting in and out. I think your gist of, we were saying there was things in the opposition that the court should not consider according to reference to Gallagher's. But if you said something else afterwards, it was cutting in and out, counsel.
Thank you, Your Honor. Yes, I was saying it was irrelevant that no defendant, perhaps except for NSF, depending on how the court rules on that, had joined our motion. The important part is no defendant had opposed. And I will add that no retail or distributor defendant has any claims against them by the outbreak plaintiffs in this case.
How about the equity portion? I mean, in asking, the reason why I was saying it wasn't really addressed in the cross claim is I didn't see before me a specific request that all the parties are requesting that it be split between a jury trial and a bench trial. Are you saying that that's conceded by everyone? Would you mind please explaining your position on that, counsel?
Sure, Your Honor. I don't, like I said, I did not see any oppositions to that part, and the jury is not going to address contribution and indemnity. Those are under the MGM Grand Fire. Those are indemnity rights that don't go to a jury. And it is my understanding that would be bifurcated. And so, if that evidence is presented simultaneously, that can be presented simultaneously at each bifurcated trial. So, for example, what the relief that Nevada Beverage is seeking is that Brody and Hunwardsen be tried first, and then that would include evidence of their alleged consumption, their alleged illness, causation, damages, etc. That would include
You're cutting in and out, counsel. It's really difficult. So these two, oops, now you're not even on audio visually. I'm not sure if we lost you. Counsel, are you still there? I can still see everybody else, so it's not an issue from the court side. Counsel, are you still there?
I am.
Okay. Oops, I don't see you. It's an empty desk. Have you left? Are you on some other panel or box? Okay. Counsel, have you completed your argument? So I should move on to opposing counsel? Because you all did not ask for a special setting, so basically, remember, I've got 43 pages of hearings today, and nobody asked me for a special setting, so let me make sure. Counsel, have you finished your oral argument? I'm going to have to take that as a yes, because I'm not hearing anything. Okay. For the joinder party, were you going to request to do oral argument? You did a non-substantive, untimely joinder.
No, Your Honor.
Okay, I'm just asking if you are. I was going to hear what your position was. I'm not making a determination. I just wanted to hear your position. And remember, counsel, we need you to state who you are so that we get you a nice, clear record, please.
This is Jonathan Fountain on behalf of NSF. We have nothing.
Appreciate it. Thank you. So then we're going to go to plaintiff's opposition. Counsel, go ahead, please.
Thank you, Your Honor. I think your inclination is correct. Mr. Dodrill, respectfully, he is saying things, but he's just saying them. There's no basis in reality for any of them. He says that the FDA investigation and all the facts and evidence from when they actually found out of the problem is not relevant to 2018 or 2019 injuries, and that it would be excluded in relation to those claims. Number one, that's not before you. That's an evidentiary issue that has not been briefed. To assume that he's correct and grant a bifurcation, which would be extremely prejudicial in these cases, is not, I think, a valid reason that he gave you. And number two, it is not true. It is absolutely not true. And you can just look at the Gallagher case. We are preparing to try the Gallagher case in front of Judge Williams on September 5th. We are in the middle of briefing more than 100 motions in limine. The Gallagher case has 7 plaintiffs as opposed to 5, all joined together in one trial. 2 of the plaintiffs out of the 7 have claims against distributor defendants. That's it. 1 plaintiff is injured in 2018, 2 in 2019, 4 in 2020. So disparate timeframes. There's been no question that all the 2020 evidence is relevant to the 2018 and 2019 claims against the retail distributors. There hasn't been any argument otherwise. In fact,
Counsel, I'm going to stop you a quick second there. Opposing counsel is correct. This is not the Gallagher case. I'm not Department 16. Judge Williams, wonderful judge, maybe on the same floor, but this is Department 31. This is a different case number. You all chose how you wish to file which plaintiffs with different case numbers, and these are coordinated, not consolidated cases. So, right, the court has to focus on what's before this court in this case.
Exactly, Judge. I completely agree, and that's my point. This issue is not before you, and when it was before another court, what they're saying wasn't true. So there's no basis for him to come in and say, oh, something that's not before you is already assumed in my favor, because there's just no basis for it. And Your Honor, I would disagree in one respect in terms of Gallagher, because even though that's a different case, we've been doing the discovery in the coordinated action that applies to this case in preparation for Gallagher first. We've done more than 80 depositions in the coordinated action. We've disclosed more than nearly 30 experts in connection with the Gallagher case. And while this is a different case, I can tell you with confidence that the vast majority of the witnesses, the evidence, the experts that have been disclosed in the Gallagher case are going to apply equally in this case. And so when you look at the law on this, and it's the twin goals. Plaintiffs are allowed to join together. And you look at it, and it's strongly encouraged to allow joinder to the broadest extent possible to promote trial convenience and final determinations of an action. And when you look at those two primary purposes of what we're looking at here, I think you obviously already recognize that one trial instead of 2 trials in this one case alone is far more efficient. And we pointed it out in the opposition, because I think another thing that Gallagher is telling is the jury. 4,800 jury summonses have gone out. We have 1,200 jury questionnaires that we just dropped off at jury services. They're bringing in hundreds of people every other day or every few days to fill out these questionnaires.
You understand the court's very familiar with the process you're utilizing and the format of the jury question, our ability to serve, and where it kind of was generated first being used. But
I know you do, and that's why I'm
sorry, for everybody else who may not be familiar, is they're utilizing a format that was done with this department in the opioid case. I'm not saying they use exactly the same, but a lot of that process they used was just recently done here. That's why I'm
We
familiar
had a
with it.
hearing with Judge Williams on this with the jury commissioner who came in to discuss how we were going to do this in the most efficient way. And it was based off what you did in the opioid case. And so you are familiar with it, and you know that that alone is an incredible burden. So doubling it is incredibly inefficient. It would double nearly the entire cost, the time. This case is one of more than 25 separate real water related actions. I mean, you have 5 of them alone. 4 of them are set for trial in 2024, pretty much back to back. I mean, Judge Alf just consolidated 2 of the separate cases for a joint trial in front of her. Judge Williams is hearing the 7 plaintiffs on September 5th. We need to get through these cases, not start chopping them up so we're trying 50 cases instead of 25. It's not practical. And especially when it's based on these just bald assertions that, oh, evidence won't be allowed in, when that issue isn't even before you, and there's not even a reasonable basis to make that contention. So, Your Honor, you had your initial inclination was to deny the motion because any bifurcation is going to be confusing, inefficient, and violate judicial economy. And that is 100% true in terms of splitting up these plaintiffs. We are having no problems with the joint trial with 7 claims under similar circumstances in Gallagher. There's no reason to believe why we'd have trouble with 5 plaintiffs in this case. So we'd ask you to deny the motion.
How about the second point about bifurcating their cross claims?
We have no opposition. If they want to have their contribution and indemnity claims heard in a separate phase of trial, we have no opposition.
Just theirs?
Well, yeah, I'm not sure any of the cross claims and indemnity claims.
Hold on one second. Somebody does not have themselves on mute, please. In consideration for counsel who's speaking, everyone would like a nice clear record. Please do put yourselves on mute, okay? We do appreciate it. Thank you so much. Counsel, I missed part of what you said because it was all the noise of someone not being on mute. Go ahead, please.
So, Your Honor, it's a little difficult to address conclusively because we're handling this in the Gallagher case right now with Judge Williams and motions in limine, and it does seem like the general consensus is going to be to handle the contribution and indemnity claims in a third phase of trial, or in that case, it might be stayed. So it really, as we get towards trial in this case, if there's not an agreement amongst all the parties and how they handle these different cross claims, then I think we can address it. So whether you want to decide it now and sever those out, or defer it until we get closer to trial and we have a little more information on what the parties are going to want to do. But from plaintiff's perspective, we don't oppose severance of those contribution and indemnity claims to a third phase of trial that's handled by the court without the jury.
It doesn't really impact you, does it?
Doesn't impact us unless there's some, as long as the evidence and arguments related to it isn't affecting our case in chief, and we would, if they're not severed out, we would make a motion to eliminate and make sure that doesn't happen. But other than that, it doesn't affect us, and we don't oppose it.
Okay, I am going to ask a question. I'm not saying I'm going to take it into consideration, but I think it is appropriate, since it was not in the captioning of the motion, and it really wasn't until you got to page 16, and it didn't specifically talk about the parties that were affected, that I think it's fair for this court at least to ask the question whether it was intentional on behalf of Affinity and Real Water, Affinity Lifestyles, Com Inc., DBA Real Water LLC, and Real Water Inc., and a third-party complaint, as it says, a third-party complaint against Real Water of Tennessee. Was it your specific intention not to oppose the portion of the motion that addressed the cross-claim and third-party claims as to Nevada Beverage only?
Your Honor, Jim Cavanaugh for Real Water of Tennessee, a third-party defendant with a third-party claim by a moving party. It was not my intention not to oppose it. In fact, shame on me, I didn't realize it was a thing until somebody pointed it out a couple of weeks later, that on the last page there's an added paragraph. So again, I didn't file an opposition. It's the word Real Water of Tennessee as a third-party defendant isn't even captioned in this particular pleading in either the motion or the reply. It's not the idea of this bifurcation of the third-party claim, let alone the cross claims, isn't even mentioned in how a company called Nevada Beverage has something to do with company in Tennessee is a whole nother issue. I did understand it was more than an equitable claim, because I assumed it was a contractual indemnity and an equitable indemnity pleading. But anyway, we didn't even know we were a subject of this. Our claim defense was the subject of this pleading. No disrespect to counsel. Colt's a very good attorney. He has very good points, I think, actually, in his pleading. But you mentioned in your opening inclination remarks it wasn't addressed. I believe it really wasn't fairly even given notice of it being an issue until after one page it goes from, therefore grant this motion, accordingly, court should grant the motion. And then the next page, there's a paragraph added for the first time in the entire motion about the cross-claim, third-party claim. I've spoken too much. Maybe Real Water Inc. and Affinity Lifestyles has a different take on it, but
and remember, I'm not going towards substantive argument. I'm just trying to find out if there was an intention not to respond, because there was a statement in the motion that nobody opposed it, but court is cognizant the cross-claim third-party claim does include express indemnity and equitable indemnity and contribution. And anyway, okay. Counsel for Real Water / Affinity, that's not Tennessee. Did you wish to be heard or not?
Your Honor, I would simply...
Remember your name first.
Yeah.
Name each time, please.
Daniel Joslyn on behalf of Real Water and Affinity Lifestyles. Again, Your Honor, I don't think that there was sort of intentional parsing out on Real Water's part in terms of the opposition. Similar to what Mr. Cavanaugh just stated, I think we were operating along the same lines on these terms.
I'm not sure what you mean by operating on the same lines among these terms. Can you please clarify a little bit?
Your Honor, I'd simply state that...
Did you intentionally not oppose it, or was there something that the court should be looking at in the lack of opposition? I have to take this into account under EDCR 2.20, so that's why I have to ask the question.
I understand, Your Honor. Real Water does not oppose the motion. There is no specific part of it that it specifically does not oppose or opposes. We are not in opposition to the motion, Your Honor.
Okay, so it was intentional not to file it, so you're fine with just Nevada Beverages it's phrased as equitable claims, right? Not even to be parsed out to a separate trial. Is that a correct or an incorrect statement, counsel?
That's correct, Your Honor.
Okay.
We do not have opposition to that.
Okay, thank you. So I got just those. Okay. So now let's go back to movement, please. And for everyone who's patiently waiting, we will get to you shortly. Thank you so much. Counsel for movement, you get last word. Go ahead, please.
Thanks, Your Honor. I'd like to address the efficiency issues. I think plaintiffs have thrown efficiency out the window when they filed 25 plus separate cases. They could have been placed in clusters of maybe 5 or 6 cases of similarly situated plaintiffs to avoid the prejudicial effect to the 1 or 2 oddball defendants like Nevada Beverage is in this position. It was our intention when we filed our motion to sever last year to pull out the 2 plaintiffs that had Nevada Beverage and then move under 42A to consolidate those so Nevada Beverage could be addressed, the plaintiffs that are suing Nevada Beverage could be addressed in 1 or 2 trials instead of the 7 that are now. Nevada Beverage is in almost half of these cases, but there's only 10 total plaintiffs. And again, this disparate cross-section creates a problem created by plaintiffs. In other words, we filed this motion to bifurcate, to cure an issue that was caused by plaintiffs and to resolve the multiple trial issue that plaintiffs are complaining about. Despite having filed 25 cases, it would be real simple to avoid the multiple trial issue, the multiple flying expert out issue, and even the third party cross claim issue by taking, for example, free outbreak in another.
Counsel, I'm hearing about every third word, and each time you move back, it's even worse.
I apologize, Your Honor. I think the easy way to resolve the multiple trial issue, which again was caused by plaintiffs structuring these complaints this way, would be to move the 3 outbreak plaintiffs, Sosa, Hartshorn, and Schaefer, to be tried in another matter, and perhaps move through the joinder, severance, bifurcation, and consolidation code sections into clusters of cases. For example, I believe counsel mentioned other cases in front of Your Honor set for trial next year. I think Richt is the next case. I'm not in that case anymore, but it would make sense pursuant to the authorities we cited to have, for example, and I'm not suggesting it be done specifically, but just by way of example, if Jesse Richt were tried with Brody and
Counsel, I'm going to stop you. I'm going to stop you just like I stopped opposing counsel. Please, the only case before this court today is Hunwardsen, 831543, not any of the other cases. I need to focus on the motion before this court in this case and the breadth and scope of the motion presented to this court in this case. Feel free, please, to finish up on your brief response so the court can make its ruling, please.
Thank you, Your Honor. In brief, plaintiffs are stopped from complaining about the multiple trial issue because that's an issue of their own creation. The number of trials is moved, should not be considered, and the cross-claim issues can be tried in those groups, and whether it's decided by the court or the jury, the evidence is the same and should not affect either the number of trials or the length of the trials.
Can you refresh the courts? There was earlier on in this case, Brody was dismissed as to Nevada Beverage only. Was Brody brought back in?
Miss Brody.
And what date? Because I was having a considerable effort in looking through the 300 plus entries to try and find where somehow there was a reference to that prior stipulation and that it was no longer enforced in fact. I know she was stipulated dismissed without prejudice as to Nevada Beverage only, but where was she brought back in, please?
Ms. Brody is always a plaintiff. She asserted claims. She bought her real water from Costco. Costco got some of the product from Nevada Beverage, but some of it directly from real water. So during discovery, we learned that the water that Ms. Brody got from Costco that made her sick was water that was distributed directly from real water to Costco, not through Nevada Beverage. So that's why we just dismissed the claims against Nevada Beverage only. But Ms. Brody has always been in the case. She was never out and then back in.
Is she? Okay. Part of her claims are still in Hunwardsen as to Nevada Beverage. That's the only person. That's the only party I'm focusing against. Or is she out as to Nevada Beverage? Because part of this motion to bifurcate is Ms. Brody as to Nevada Beverage. That's why the court has to ask the question. Is she in Hunwardsen as to Nevada Beverage? Half, whole, or not at all?
And I don't want to misspeak. I think Ms. Brody, Colt did, we dismissed Ms. Brody's claims against Nevada Beverage.
That is correct. Ms. Brody has no claims against Nevada Beverage.
Then Ms. Brody has no claims against Nevada Beverage. That's correct.
There's an NEO on 5/3/2023.
Yes, we've figured that out and changed things in the cases a couple times, and I just wasn't certain, but it is consistent with my recollection and what you're saying and what Colt said. So yes, no dispute there.
But the reason why the court's asking the question, this motion asked to bifurcate Ms. Brody as to Nevada Beverage when it appears she's not in the case.
Yeah, if I can clarify, Your Honor, I didn't move to bifurcate anybody as to Nevada Beverage. I moved to bifurcate two plaintiffs' claims from against everybody they're suing.
So how can you do that? Counsel, how would you have the standing? That's why I would ask my question at the very beginning, right? Were you only as to Nevada Beverage? So how can you move on behalf of everybody else to bifurcate the claims on parties you don't represent? I did not see that you set forth any authority on that.
Your Honor, my authority comes from Rules 20B and 42B. I moved to bifurcate the trial. I'm not trying to get a separate trial just for Nevada Beverage. I'm trying to draw a line of demarcation between the two plaintiffs that can be tried together against the retail entities, which in this case, Brody has claims against Costco, and Hunwardsen has claims against other retailers, including Terrible Herbst, which brings in Nevada Beverage. The other three plaintiffs have no claim against Costco, Terrible Herbst, Nevada Beverage, UNFW, Whole Foods, and that's exactly the language of 20B that the court referenced at our last hearing. You can separate claims by that just have no bearing to each other, and so that's the line. And I think that might have been some confusion, and it came from us. We apologize, but what we're asking for is two trials. One is Brody and Hunwardsen going to trial against the defendants they're making claims against, and the second trial, and whether the court does something after the fact related to those, I don't care, because none of those folks are suing me, but those three, Sosa, Hartshorn, and Schaefer, go to another trial against that they are suing.
Counsel, it's so hard to hear you. please, you gotta make sure, if you want to appear remotely, you have to ensure, right? The rule specifically says you need to ensure and test that you have an appropriate connection. So it's very, very challenging. Okay, so your 20B, right, is persons may be joined in one action as defendants if any right of relief is asserted. Okay, common question to all defendants. That's your 20B. So then you go to, I'm not seeing, basis, realistically, of how you're asserting on behalf of parties you don't represent that Ms. Brody should have a separate trial. That's why I was asking the question at the beginning as to Nevada Beverage, because you can't assert a cross-claim with regards to Ms. Brody if you're not being sued by Ms. Brody, because there'd be nothing right for you to be indemnified or contributed to if she's out of the case as to Nevada Beverage. So
That's
please,
right, Your Honor. I'm moving under 20B, which says protective measures. The court may issue orders, including for a separate trial, to protect a party against prejudice that arises from including a person against whom the party asserts no claim and who asserts no claim against the party. So Hartshorn, Sosa, and Schaefer assert no claims against Nevada Beverage. So I moved to sever them because the evidence for them is completely different than the evidence of Hunwardsen's claims against my client. And if the defendants disagreed and said, whoa, Nevada Beverage is overreaching, or Nevada Beverage doesn't, that's going to affect other dynamics of the case, the other defendants could have raised that. But Rule 20 says the court may issue orders to protect a party. Nevada Beverage is a party. Nevada Beverage is going to be prejudiced by these unrelated plaintiffs that aren't asserting any claims against my client, and that is going to prejudice us. So the standing comes from Rule 20.
but Ms. Brody, how are you putting her in this grouping? Because she does not have any claims against your client. How are you asserting that the trial, right, the 20B, by the way, your motion's phrased a little bit differently, right? If you read the first, okay, as your introduction sets forth, and this is why the court's asking the question, okay, to avoid prejudice and unfairness will result in a consolidated trial against plaintiffs against all defendants, defendant Nevada Beverage by and through its counsel, etc., moves pursuant to 20B and NRCP 42B to bifurcate the trials of plaintiffs Myles, Hunwardsen, and Miriam Brody, who are unrelated to the 2020 outbreak of non-viral hepatitis alleged in the complaint. So your affirmative relief is to bifurcate somebody out who does not have any claims, so you're not a... That's the issue would be the way that you're seeking this relief. How are you placing Ms. Brody with Mr. Hunwardsen when there are no claims by Ms. Brody against your client?
I can answer that, Your Honor, and I understand the court's question. To be fair, because Ms. Brody now is no longer asserting claims against me, I don't care when and where she's tried. What I wanted to do through this motion, based on the authorities, was to find a logical way to bifurcate this and prevent something that makes sense, and not have plaintiff come back and say, well, now we have to try every plaintiff separately. I understand that's not possible. What makes sense is to find the line that makes logical clusters of plaintiffs. And both Hunwardsen and Brody are similarly situated based on temporal elements and based on predating and not being related or associated with any of the series of unfortunate events from 2020 that may or may not have led to the outbreak and the investigation and all of that has no bearing on pre. So I don't think the court would be inclined to try Brody separately and then try Hunwardsen separately. So I wanted to find, again, under Rule 1, a logical compromise so that we could have bifurcation and still have efficiency. And so that's the line that makes the most sense. If I was plaintiff's counsel, I would have grouped all my non-retail drinking outbreak plaintiffs.
Counsel, I appreciate it. Really, my question was very specific, not what you may have done as plaintiff's counsel, right? I do need to focus on the actual motion before me, what is citations in the motions before me, the opposition, the reply, and then also taking into account the non-substantive joinder, okay? So I appreciate it. I need to, it's now been almost an hour and nobody asked me for a special setting, so please in the future, court, as you know, gives you all special settings all the time, but in fairness to everyone, so they don't have to wait impermissibly. If the argument's going to be more than just a few moments, please let us know so we can get you a special setting. So here's the court's ruling. The court's going to deny the motion to bifurcate. The trial, document 317, for a variety of different reasons. Basically, the court, A, is adopting its inclination, but also adding in specifically the references to Rule 1, scope and purpose, right? Rules of procedure. They should be construed, administered, and employed by the court, and the parties should secure the just, speedy, and inexpensive determination of every action and proceeding. This would not do that. It would not meet that goal. It also doesn't meet the goal of 20B. It would not be issuing an order, including an order for separate trials to protect a party against embarrassment, delay, expense, or other prejudice that arises from including a person against whom the party asserts no claim and who asserts no claim against the party. Realistically, by combining the way that it's being sought with Hunwardsen and Brody, by Nevada Beverage, when there's no claims by Brody against Nevada Beverage, really the court, A, sees a standing issue how asserting that, and I appreciate that you say it really doesn't matter, but it might make sense to do it anyway, but really what that does is this is parsing it out in multiple trials, and this multiple trials that don't even really take into account the cross-claim issues, because the cross-claim is only as to one party, not another party. For Nevada Beverage, it would be parsing out the Nevada Beverage component versus the other defendants in the case, and so it does not meet either 1 or 20. It also does, 42 really is the, as you know, is the consolidation component, and consolidating separate trials, it's you asking to have, for convenience to avoid prejudice or to expedite a contents court may order a separate trial, one or more separate issues, claims, cross-claims, counterclaims, or third-party claims. When ordering a separate trial, the court must preserve any right to a jury trial. So that part, the jury trial right, doesn't really apply to some of the potential indemnity and contribution claims, specifically with regards to Brody, because while the court's not making any affirmative determination, at this juncture, nobody's shown me that there could be contribution indemnity when the person doesn't have any first-party claims, but once again, I'm not ruling on that because it's not yet before me. No one's affirmatively brought that forward to the court in any manner. But second or third or whatever number I'm at this juncture is it really just doesn't make sense. And it doesn't give any efficiency, because what the jury would have to hear is, well, here's some of the claims as to some of the parties with a huge amount of overlapping facts. You have a whole bunch of experts who are going to define on things, which are also asking this court to make a predetermination of factual issues that have not been fully presented to this court, i.e., what is or is not the relationship between things that happened in 2000. Please, okay, I'm in the middle of making a ruling. Some people might actually care about this ruling, so please put yourselves on mute so you're not interrupting another hearing. Please, thank you so very much. I'm more than glad to accommodate remote appearances, but people have to be considerate of hearings. Okay, so I have to repeat myself a bit, so let's go back. It does not do any of the efficiency, does not meet the needs to have these parse outs of some subpart out with regards to Nevada Beverage. I have issues with regards to other defendants who have not affirmatively requested it, but realistically, you have an overlap potentially of experts. You have asking this court to make an affirmative determination that things in 2018 and 2019 were distinct from 2020, okay, which right now, that's just purely argument. That's not been presented to this court as any affirmative determination, which would be a necessary prerequisite in order to take the analysis that's been presented by the motion in order to find that it would meet the needs under 1 or 20 or 42. And so the court, since that has not been made an affirmative determination, can't say that that is already the predicate that would allow the court to do it under 1, NRCP 1, NRCP 20, or NRCP 42. Instead, at this juncture, court finds that the case as is, since the movement has not met their burden, the court needs to deny the motion. In so doing, however, the court is not making a ruling with regards to what may turn out to be equitable claims. The court really, in that portion of the ruling, I am seeing that it wasn't really fully presented to this court. Like I said, it showed up for the first page on page 16 without even saying who the parties were impacted, who the parties really that was tied to. It was referencing, it says the equitable claims, third-party claims. It doesn't even reference which ones or which was those asserted. I mean, is it referencing both the contractual and the equitable indemnity? Excuse me, it's the first cause of action. And so at this juncture, the court really, in that regard, I don't think it's fully presented to this court. So whether you wish to phrase that I don't view it as fully presented to the court, so the court needs to deny it without prejudice, or whether you wish to view it that the court's going to defer that till all parties have an opportunity closer to the time that needs to be affirmatively presented to the court, whether it's by stipulation, whether it's by motion practice, whatever the issue is, so that everybody can weigh in on that, not on something that kind of is put in a paragraph on a last page, which is not really focused on. So whether you want to view that as deferred or denied without prejudice, you really could view it either way, but the court's not saying it can't be brought up once I have the appropriate information presented to this court as to the scope of what really is being requested. Is it all three causes of action just in that cross-claim? Because that cross-claim is only as to affinity, but yet this was a motion that addressed in part claims to plaintiff and then kind of mentioned things with some of the affinity parties, but never mentioned which affinity parties it was referencing. It just kind of gave a general statement without setting forth the actual entities that it was based upon. And one of those, and whether it was as to both, you know, it potentially could be as Hunwardsen, but it wasn't even specified there. So what it means is the court's ruling is denied without prejudice as the portion to bifurcate or sever Hunwardsen and Brody as to Nevada Beverage, which is and also NSF's non-substantive joinder. Since I'm denying it, I'm going to take it into account. I don't see that, and SF has set forth any reasonings, and so it's non-substantive joinder for all the reasons I've stated with regards to Nevada Beverage would apply to NSF, and since NSF did not make any distinction between Brody and Hunwardsen, I can't make that distinction, but I'm not saying whether Brody is into NSF or not. You all would have had to have brought that to the court's attention. You didn't, so I take the joinder as is, even though it is untimely, but I'm still evaluating it. I'm not in any way waiving any objections that procedurally has been made by plaintiffs. I just think since we're addressing it, I might as well address it as well at this juncture. With regards to the second portion of the motion to bifurcate to the extent it goes to some kind of claims against some entities as to Nevada Beverage, which may be as to unclear whether it's to 5 plaintiffs, 4 plaintiffs, or some subpart that it only applies to Hunwardsen and not to the other 3 for 2020. Realistically, the court doesn't see that is fully presented to the court, so I don't think you've met your burden independently. Even if you view that it is fully presented to the court, then the court would have to view that is needing to be deferred until it's actually presented to the court on a clarity of what actually is being sought as to which causes of action, as to which claims and which parties. It is so ordered. That means counsel for the non-movement, you're preparing the order, circulating it to everybody else, and providing it back to the court in accordance with EDCR 7.21 within the 14 days to the DC 31 inbox in accordance with the administrative order. Thank you all for your time. It looks like the next time I am seeing you is a status check on 8/1/2023. Thank you so very much, everyone, and we're moving on. Appreciate it.
Your Honor, thanks for your time and patience.
Thank you.
Okay.
Thank you, Your Honor.
Thank you, I appreciate it.
Thank you.